Welcome to the Deep Dive. Today we are taking on a case that is, well, it's absolutely seismic in its complexity and profoundly troubling, really.
Oh, absolutely, because it involves the highest levels of the Australian legal system, doesn't it? You've got a mysterious death, a really controversial acquittal.
And then this decade-long fallout. Legal battles over police conduct, defamation. It's just huge.
When you really dig into these sources, this case, it sort of goes beyond just a crime file. It feels more like a forensic examination of the justice system itself.
How so?
Well, what happens when both the accused and the victim are senior figures inside that system? What happens when there's intense suspicion, like really intense, but the actual physical evidence is, well, it's bafflingly ambiguous.
Okay, right. Let's unpack this and set the scene for you listening. We are diving into very complex sources concerning the killing of Corryn Rayney in Perth, Western Australia, back in 2007. Now, Corryn was a registrar at the Supreme Court of Western Australia.
And her death, crucially, remains unsolved, despite the fact that her husband, Lloyd Rayney, who was himself a very prominent criminal prosecution barrister, was charged with her murder.
So our mission today is really focused. We want to try and cut through years of, media hype and speculation.
Yeah, we're sticking just to what the official records show. So court records, the detailed judgments, the official inquiries that came later, like from the Corruption and Crime Commission.
We'll unpack the investigation, the trial, which was unprecedented, a judge-only trial, and then this really contentious aftermath, which bizarrely saw Rayney win millions in damages.
While at the same time losing his entire legal career, it's quite the paradox.
Let's just quickly sketch out the people involved because their positions are so central here. Corryn Veronica Ann Rayney, née Da Silva. She was born in Uganda in 1963.
Right. Her family came to Australia in '73 as refugees fleeing Idi Amin, Indian heritage.
And she had this path of, well, immense achievement, rising through the legal ranks to become a registrar at the Supreme Court.
And that position, you really need to understand the significance.
Yeah.
A Supreme Court registrar isn't just like an admin role. They have quasi-judicial functions. They're senior, respected, part of the fabric of the WA judicial system.
And her husband, Lloyd Rayney, was an equally powerful figure in his own sphere, a successful, well-known criminal prosecution barrister.
So these were people who understood the justice system inside and out, which I think made what followed even more shocking, both for the public and, for the legal profession itself.
Yeah, that initial shockwave.
Yeah.
It really rippled across the entire Australian legal community.
Yeah.
A top barrister charged with murdering his wife, a senior court official.
Yeah.
It's almost unbelievable.
And there's another layer here, kind of a pre-existing tension. You have to know that at the time Corryn disappeared, Lloyd Rayney was already, let's say, a person of interest to some in law enforcement.
Oh, really? Why was that?
He was involved in a completely separate Corruption and Crime Commission inquiry. This one was looking into alleged police misconduct in a totally different murder case he'd been involved in as counsel.
Wow. Okay, so there was already friction there between Rayney and elements of the police force.
It seems so. And that provides this really complicated backdrop when the investigation into Corryn's death actually began. It suggests maybe that some parts of the police might have already viewed Rayney with suspicion, or maybe even antagonism, long before he was officially named as the suspect in his wife's death.
Right. That context is definitely important to keep in mind.
Yeah.
Okay, let's get into the official narrative. Starting August 2007, the facts, the timeline of loss.
Yeah, the timeline is incredibly tight, and it was intensely scrutinized. Both sides, defense and prosecution, picked over every minute.
So what do we know for sure?
Corryn Rayney was last seen alive around 9:30 p.m. on Tuesday, 7 August 2007. She was at her regular weekly boot scooting class. In Bentley, that was.
Boot scooting? Okay.
Yes. And then shortly after that, she was reported missing. Her car was gone too, a 2005 Ford Fairmont.
Then nothing for a week. That must have been agonizing.
It was. Then, a major turn. On August 14th, her car, that distinctive silver Ford Fairmont, it turns up abandoned on a residential street in Subiaco.
Which is a different suburb entirely.
Right.
Not near the class, not near their home in Como.
Exactly. A completely different area.
And finding the car led them to her.
It was the critical link. 2 days after the car was found, so August 16th, her body was located. Police followed an oil trail, apparently leaking from the car, starting near where it was abandoned.
An oil trail? Seriously?
Yeah, seems so. And that trail led them into Kings Park, specifically to the shallow, hidden grave off Lovekin Drive.
And police knew straight away it was homicide.
Confirmed immediately. They treated it as murder from the outset.
Okay, But here's where things get, well, complicated, right? The cause of death. This seems to be the absolute crux of the whole case.
It really is. This is where it shifts from a, standard murder investigation into this high-stakes legal puzzle. The defining feature is the medical legal ambiguity. The specific cause of Corryn's death was not clearly established.
Not clearly established.
No. And that ambiguity became utterly central to Lloyd Rayney's eventual acquittal. It's the foundation the prosecution's case really struggled with.
Who testified about this? The forensic experts.
Two key witnesses on the pathology. There was forensic Dr. John Hilton and neuropathologist Dr. Victoria Fabian. Both of them testified that while Corryn definitely had injuries, head, neck, brain of lifey, they couldn't definitively pinpoint the specific thing that killed her.
That seems highly unusual for a murder trial. If there's trauma, surely they know what caused the death.
You'd think so. But Dr. Fabian's testimony was particularly crucial here. She said the injuries suggested some kind of neck restraint had been applied.
Okay, so strangulation.
Well, no. That's the key point she made, not to the point of strangulation. And crucially, she stated the injuries she saw were not sufficient in themselves to actually cause death.
So the mechanism of death, the actual thing that stopped her life, remained unclear. They knew there was trauma, but couldn't say that trauma was the fatal blow.
Exactly that. The killing blow remained elusive. Dr. Fabian did find bleeding between the intervertebral discs in the neck, which confirmed, a traumatic event happened.
But then Dr. Hilton's testimony added even more uncertainty.
It did. He described the injuries as consistent with compressive forces, and he used the term rabbit punches.
Rabbit punches, what are those?
Sort of short, sharp blows, often to the back of the neck or head. But the real kicker wasn't just the nature of the injury, it was the timing. When exactly did those neck injuries occur relative to the moment of death?
Ah, the timing. Okay, how did that complicate things? Especially with her being found in that shallow grave.
This is the absolute core issue the defense latched onto, and Justice Martin, the trial judge, accepted this ambiguity. Dr. Hilton stated under oath that he couldn't rule out the possibility Mrs. Rayney got her neck injuries as she was placed headfirst into the grave.
Wait, say that again? He couldn't rule out that the injuries happened while she was being put in the grave?
Precisely. If she was still alive, or only very recently deceased, and was then forcibly pushed headfirst into that grave, the trauma of that action itself could potentially have caused the neck injuries they observed.
Wow. So even though he confirmed the injuries happened before death?
He couldn't definitively say if they happened during the initial attack, which the prosecution guessed happened at home, or during the later act of concealment in Kings Park.
Which means the defense could argue those injuries weren't necessarily part of the lethal act, but happened during the disposal of the body.
Exactly. And if you can't definitively prove the act that caused death, proving who did it becomes vastly harder. You're forced back onto circumstantial evidence, not forensic certainty.
A huge hole in the prosecution case, then.
Absolutely massive. And to top it off, standard toxicology found no drugs, no poison. So the prosecution was really stripped of that clean, decisive evidence you usually need for a murder conviction. They were left relying on context, conjecture, and crucially, character.
And that lack of clear forensic proof meant the police had to build their case using circumstantial links. But the investigation itself, well, it was controversial right from the get-go, wasn't it?
Oh, profoundly. This is where it gets, as you said, really interesting, because the police actions themselves immediately put the whole thing under a cloud.
Why not?
You have to remember, this happened 3 years before charges were even laid. In September 2007, just a month after Corryn's body was found, the lead investigator, Senior Sergeant Jack Lee, holds a press conference.
Okay.
And at that press conference, he controversially calls Lloyd Rayney the only suspect.
Only suspect. A month in, that sounds premature. And incredibly prejudicial for Rayney.
It was hugely controversial to publicly name such a high-profile person as the single focus of a murder investigation. I mean, it implies you've basically made up your mind before the investigation is even close to finished. Massive ethical questions there.
And the courts later agreed it was damaging.
Extremely damaging, yes. The civil courts confirmed that later. That statement, made 3 full years before Rayney was finally charged in December 2010, effectively made getting an impartial jury in Western Australia, well, pretty much impossible.
Which explains the next really unusual step, the trial itself. No jury.
Exactly. A legal rarity in Australia for a murder charge. The trial started in July 2012, heard by a judge alone. The defense successfully argued that the massive, sustained, and frankly deeply prejudicial publicity stemming in large part from that only suspect comment made a fair jury trial impossible.
And to ensure impartiality, given everyone's status in the WA legal world.
They brought in an outsider. Former Northern Territory Chief Justice Brian Ross Martin presided. He was appointed specifically from outside WA to hear the case, just to make sure the judgment was seen as completely independent.
So you've got this unique setup, external judge, no jury, facing a case built entirely on circumstantial evidence because the forensics were so shaky.
That's the landscape.
So what was the prosecution's actual story, their hypothesis of what happened?
They alleged Rayney killed Corryn at their family home in Como, maybe after some kind of argument. Then they suggested he dragged her body along the driveway, which is important, later put her in her own car, drove her out to Kings Park to bury her in that shallow grave, then dumped the car somewhere else, in Subiaco, before somehow getting back home.
Okay, let's break down the evidence they used to support that theory. Starting with motive, why would he do it, according to them?
The motive was painted as this really high-stakes breakdown. Marital problems, affairs. Lloyd Rayney had affairs, the sources confirm that, and significantly, a serious gambling problem.
How serious?
Apparently lost nearly $50,000 to Centrabet in just over a year, between April 2006 and July 2007.
Wow, okay, that's definite financial pressure.
Yeah.
But the prosecution argued Corryn was doing something specific that threatened him professionally.
That was the key pressure point, they argued. Corryn allegedly threatened to subpoena his clients, but his legal fees specifically, if he refused to disclose his true financial situation during their separation and divorce proceedings.
And for a barrister, having clients subpoenaed about fees.
It's potentially catastrophic. It could reveal confidential financial dealings, damage his reputation, impact his income. The prosecution argued this gave Rayney a powerful motive to silence her permanently.
They also brought up evidence about his conduct, things unrelated to the actual killing, but showing his character.
Yes, the discreditable conduct. This was big. Lloyd Rayney was found to have been secretly recording his wife's phone calls and conversations.
Which is illegal, right? Surveillance Devices Act.
Absolutely illegal. And it showed he was actively trying to gather dirt on her, presumably to help his side in the separation battle.
So, motive, bad character. What about physical evidence linking him or the house to the crime scenes?
Okay, three main pieces here. First, a small dinner place card. It had Lloyd Rayney's name on it, found near the burial site in Kings Park.
Okay. That's odd.
Second, forensic analysis found tiny traces of brick dust and soil on Corryn's body. The prosecution argued this was consistent with her body being dragged along a specific brick-paved part of the Rayney's driveway at the Como house.
Right, connecting the body back to the house. And the third piece was botanical, the seed pods.
Yes, the liquid ambar seed pods, found tangled in Corryn's hair. The prosecution brought evidence that these pods matched a liquid ambar tree right there at the family home in Como.
But not in Kings Park where she was found.
Correct. Critically, they argued, this type of tree wasn't native or present in that remote bush area of Kings Park, so the inference was clear. The pods must have got in her hair back at the Como house during the attack or when her body was first handled.
Okay, so Justice Martin is faced with this incredibly complex picture. High-profile defendant, ambiguous cause of death, but strong motive evidence, illegal surveillance showing dishonesty, and these forensic traces, the card, the dust, the seeds, all pointing circumstantially back to the house and to Rayney.
It was an immense task, but this is where the judge-only trial gives us such valuable insight into the reasoning. Justice Martin delivered his verdict on November 1st, 2012.
And the verdict was?
Not guilty.
Why? What was his core reasoning?
Fundamentally, he found the state had failed to prove guilt beyond a reasonable doubt. He explicitly said the prosecution's case was, quote, beset by improbabilities and uncertainties.
Such as?
Well, for instance, he questioned things like, why would a trained, intelligent barrister drag a body across a brick driveway, potentially leaving traces? Why commit a murder that left so little forensic evidence on himself, only to apparently drop his own name card near the burial site? It just didn't quite add up logically for him.
But he didn't let Rayney off the hook entirely in his comments, did he? He had some pretty harsh words about his character.
Oh, absolutely not. Justice Martin was scathing about Rayney's behavior. He specifically highlighted the discreditable conduct, the illegal phone tapping, making a false declaration to authorities, and crucially, giving deliberately false evidence under oath in court proceedings.
So he basically called him a liar.
Pretty much. He said this conduct raised suspicion, in some instances, quite strong suspicion, about his involvement in his wife's death.
But this is the vital legal point, right?
Yeah.
Suspicion isn't enough.
Exactly. This is crucial for anyone trying to understand how the law works. Justice Martin stated it plainly. Discreditable conduct does not prove guilt, and suspicion, even strong suspicion, falls well short of proof beyond reasonable doubt.
So just because the judge believed Rayney was dishonest and acted illegally in other ways.
That evidence couldn't legally be used to say, well, he's the type of person who might kill his wife. The prosecution still had to prove the murder itself beyond reasonable doubt based on the evidence directly related to the crime. And Justice Martin found they simply hadn't closed those circumstantial gaps to meet that extremely high standard.
Okay, so the acquittal happens, but that's really only the halfway point in this whole massive legal saga, isn't it?
Not even halfway, maybe. It immediately kicked off huge questions about the investigation itself, the police conduct.
And for Lloyd Rayney, it was the start of this relentless fight to, I guess, salvage his reputation in his career.
Well, first, the criminal side had to be fully wrapped up. The prosecutors, they appealed the acquittal straight away.
Did that go anywhere?
No. The appeal was heard in August 2013. Again, they brought in 3 judges from other states to ensure impartiality, and they unanimously dismissed the appeal. They completely upheld Justice Martin's acquittal. So criminally, the case was definitively closed, not guilty.
But Justice Martin's comments about the police conduct,
Yeah.
that opened up a whole new can of worms, right? Systemic scrutiny.
Oh, massively. His judgment contains strong criticism of some police actions, and that led to intense public calls for accountability, for consequences for officers who had allegedly, given misleading evidence, pressured a forensic pathologist to change his report, abused their position of authority, and behave reprehensibly. Those were the kinds of accusations flying around.
And was there an official investigation into that?
Yes, the Corruption and Crime Commission, the CCC, looked into it. Their findings were... well, they were mixed, but deeply unsettling for the police force.
How so?
They cleared 2 officers of serious misconduct over allegations they'd threatened a female lawyer involved in the case earlier on. But even in clearing them, the CCC said their behavior ranged from inappropriate to reprehensible. So not exactly a clean bill of health.
But the finding about the forensic evidence, that seems even more serious for the integrity of the case.
Yeah, I think so too. The CCC found a 3rd officer had acted unreasonably. How? By trying to encourage an independent pathologist to change their report, essentially to make it fit better with the police theory, the theory that only pointed at Rayney.
Trying to influence an independent expert? That's huge.
It strikes right at the heart of the justice process, doesn't it? These findings really backed up Justice Martin's original doubts about the reliability of some of the evidence the state had presented.
So you've got Rayney acquitted, and now there's official confirmation of police overreach and questionable conduct during the investigation that targeted him. He must have used that.
Oh, he absolutely did. He took this evidence of reputational damage straight to the civil courts.
This is where the defamation suits come in.
Yeah.
Against the state.
Exactly. This is where that fascinating tension between the criminal standard of proof beyond reasonable doubt and the civil standard balance of probabilities really comes into play. Lloyd Rayney sued the state of Western Australia for defamation, specifically over that press conference where police called him the prime and only suspect.
And the outcome?
He won, big time. In December 2017, the Supreme Court of WA awarded him $2.62 million in damages against the state.
$2.6 million, wow.
Yeah, it was one of the highest defamation payouts in Australian history at the time.
Why so much? What was the reasoning?
Well, in civil court, damages are about the harm done to the plaintiff's reputation and, crucially, their earning capacity. Rayney was a high-profile, successful barrister. The court found that the police publicly naming him like that so early and definitively essentially destroyed his professional life. Irrespective of the later acquittal, the damage was done. He became toxic in the legal world.
And in civil court, he only had to prove it was more likely than not that the state's actions damaged him.
Exactly. Balance of probabilities. A much lower bar than beyond reasonable doubt. And on that standard, the court found it was overwhelmingly clear the state had defamed him and caused massive damage by singling him out like that.
So he uses the same broad set of facts that got him acquitted in criminal court to win millions in civil court. But the story doesn't stop there, does it? It comes back to his own conduct.
That's the incredible contrast, isn't it? While he's getting compensated for the damage done to him, he's facing this relentless scrutiny over his own ethical failings, the ones Justice Martin highlights.
Secret recordings.
Primarily, yes. In 2015, the Legal Practice Board actually canceled his license to practice law. The grounds were breaching the Surveillance Devices Act, taping his wife, and also for disposing of the recording devices after police issued a warrant for them.
Disposing of them, that looks like trying to hide evidence.
It certainly could be interpreted that way. Now, he did get temporarily reinstated in 2016. The State Administrative Tribunal cleared him of a separate specific charge of unlawful destruction of evidence or perverting the course of justice in relation to that disposal. But the overall ethical battle continued.
Until a final ruling.
Until the final hammer blow, really. April 2020. The full bench of the Supreme Court of Western Australia, the highest court in the state, officially struck Lloyd Rayney off the roll of legal practitioners. Permanently.
And the reason for being struck off, was it the murder allegation resurfacing?
No, not at all. It was purely about his established professional misconduct and dishonesty. The court explicitly cited two main reasons: secretly recording his wife, which was illegal and unethical, and critically knowingly giving false evidence about those recordings while under oath in court.
So lying to the court, that's the ultimate sin for a lawyer.
Pretty much. So you see this powerful dynamic. He fails to meet the criminal bar for murder, leading to acquittal and a huge civil win for defamation. But he also fails to meet the ethical bar of honesty required of a lawyer, leading to the complete destruction of his career.
It's an incredible paradox.
Yeah.
Innocent of murder in the eyes of the law, but found guilty effectively of being a liar and engaging in serious illegal and unethical conduct.
And his career wasn't ultimately destroyed by the murder accusation itself, but by the dishonest actions he took, arguably, while trying to deal with the breakdown of his marriage and the subsequent investigation.
So through all these legal twists and turns, the defamation suits, the striking off, the one core fact that just hangs there is that Corryn Rayney's murder is still unsolved.
It's the ultimate painful, unresolved truth. It's an open wound. And the sources strongly suggest that the intense, maybe even blinkered focus on Lloyd Rayney might have cost the investigation vital time and avenues early on.
Did the defense raise this during the trial, point to other possibilities?
Oh, yes. His lawyers explicitly highlighted what they saw as the flaws in the police's tunnel vision. They identified at least two other individuals, known criminals with relevant histories, who they argued should have been investigated with as much rigor as Mr. Rayney if the police had kept a genuinely open mind.
And you mentioned earlier, some of the forensic evidence didn't neatly fit the husband-did-it theory, something about the nature of the attack.
Yes, and that's a really important detail that often gets lost in the drama of the Rayney trial itself. Justice Martin, in his judgment summary, specifically noted that some of the police and forensic evidence gathered was actually consistent with a sexual attack on Mrs. Rayney.
A sexual attack by a third party.
That was a possibility the evidence raised. But that line of inquiry, an attack perhaps involving sexual violence by someone else, seems to have never been fully explored or reconciled with the police's primary focus on her husband.
So what's happened since the acquittal and all the fallout? Have there been fresh efforts to find the actual killer?
Well, the WA police commissioner at the time, Carl O'Callaghan, did order a cold case review back in May 2015.
Did anything come of it?
Apparently not. It didn't result in any new charges being laid, but the public pressure and this lingering belief that maybe leads were missed or ignored, it hasn't gone away.
Still calls for action now.
As recently as November 2022, yeah. Renewed calls for a completely new probe into Corryn's death. These calls cited new potential witnesses who claimed they'd given relevant information to police way back when, information they felt was never properly followed up.
It just leaves you with this profound sense of incompleteness and difficulty. We have a man acquitted of murder who the court also found engaged in serious illegal conduct and who won millions because he was unjustly targeted.
It's a mess, isn't it? The sources really illustrate a system that, in this instance, arguably failed the victim by not finding her killer, and also failed the integrity of its own processes, highlighted by the police conduct issues and the defamation payout.
It really throws that tension between different parts of the justice system into sharp relief.
Absolutely. What really stands out is that huge difference in the burden of proof. The incredibly high bar beyond reasonable doubt needed for a criminal conviction, compared to the much lower, more sort of common sense bar balance of probabilities used for proving civil defamation or professional misconduct.
So the acquittal says the state couldn't prove guilt to that highest standard.
Right. The defamation win says the state did unjustly ruin his reputation on the balance of probabilities.
And the striking off says he was professionally unfit because he lied and broke the law, again judged on that lower standard of proof related to ethical conduct.
And woven through all of that are the repeated exposures of failures in the initial police investigation.
Exactly. So if we try to synthesize this, what does this whole saga tell us, maybe, about the justice system's capacity to handle these really high-profile, internally sensitive cases, especially when the integrity of the investigation itself comes under such heavy fire?
Well, the consequences are huge, weren't they? The intense focus on one suspect, that controversial press conference, the alleged pressure on pathologists. These weren't just factors that might have contributed to an acquittal. They demonstrably led to one of the biggest defamation payouts in Australian history, all funded by the taxpayer. That's a systemic failure with tangible costs.
And the final, unavoidable question just hangs there. Who did kill Corryn Rayney?
And how many other possibilities, how many other leads were potentially missed or downplayed because of that immediate, very public, and highly questionable declaration that her husband was the only suspect?
That really is the thought that lingers, isn't it?
It is. This case is such a powerful, if tragic, reminder that not guilty isn't the same as innocent. It's a legal finding that the state failed to meet its burden of proof. And sometimes, like here, that failure allows the underlying problems of the investigation itself to be dragged into the light through all the subsequent legal battles. It's just a compelling, chilling puzzle that, well over 15 years later, remains tragically open.